Good evening, one and all. First of all, I'm very highly honored to welcome our guest speaker today, Shri Honorable Justice R.V. Easwar sir,
Thank you.
the former judge of Delhi High Court and senior advocate, who has been kind enough to spare his valuable time for the benefit of all the students like me. I'm also a student, friends like you. And of course, there are several members who have also shown their interest in joining us today. To learn about greater heights in the profession, how do we go about? This is all the episode about which we are going to listen to Ishwar sir today. We have with us today our host speaker Aditya Ajgaonkar, who happens to be backbone of this committee and also member of our commercial and law committees. And I just noticed and I acknowledge also right behind him there is very beautiful picture of the greater heights what we are seeing and what we are going to achieve. That is the whole motto of this episode. So Aditya is very rightly selected his background today. Friends, this is eighth episode of Udaan, and Udaan is something as the name suggests that we reach higher and higher in the sky in our professional fields or whether otherwise. And I must compliment the chairperson Niyati and her team, Charmi, Shreyas, Ankit, Akash, and everyone to carry forward this particular purpose of the chamber. Because these are the rare moments. Like, today we are all here to witness very great session with none other than our Justice Sir Shri Ishwarji, who has been otherwise it's very difficult for him to spare the time out of his very busy schedule. And he has spared the time for all the students. For the students, he is readily available at any given time, for which we are all grateful to Ishwar sir. I'll not take much of the time between you and the session. Over to the organizers. Happy learning and happy experiencing the peaks of the mountain.
Thank you, Vijay sir. Friends, a very warm welcome to our 8th episode of Udaan, which is our flagship series aimed at inspiring and motivating student and young professionals. We are truly honored today to be joined by Honorable Justice R.V. Easwar, whose profound knowledge and extensive experience in law and taxation will surely provide us with valuable insights. As I'm very thrilled to share a bit about our committee's activities. Over the past years, we have organized numerous programs to enhance the learning and professional development. We have been organizing various long duration courses like orientation courses for our CA students. We also launched the income tax certificate course called the Practical Income Tax and Litigation with Government Law College. We are also in the process of organizing a tech series and also a course on GST. So this GST course will again be within collaboration with Government Law College. We are also coming up with a 2-day course on M&A. We organize many such webinars, seminars, workshops. So please subscribe to our social media handles and so that you are updated on all our activities. And we try and cover up activities which are beneficial not only for CA students, but also for law students, for company secretaries. So we try and cover exhaustively all the subjects as far as possible, which will help you in your professional development. Apart from that, we also provide a lot of networking opportunities. We also come up with a journal, a quarterly journal. It's an e-journal, which we publish on our website, which is for the students, by the students, called Jigyasa, and where the students can contribute their articles on various topics. We suggest topics. You can also submit article of your choice, which is reviewed by the experts in the profession. So I request all of our participants, so all the students, if to contribute to the journal, which will help you hone your reading and writing, researching skills as well. We organize a lot of competitions like the Dastur National Moot Court competition. We also organize the exclusively, is the only exclusive moot court in India on indirect taxation with ILS Law College. We also organize debate competition with HR College of Commerce and Economics. essay competitions. So please do participate in all our competitions and take the benefit. Now, with that, I request so all the students and professionals who are not yet members of Chamber, please become a member, because it gives you not only the benefit of like certain free webinars and courses, but also discounts on many of our flagship events. And so without further ado, I would like to invite CA Charmi Shah, Vice Chairperson of the Student Committee, to formally introduce our esteemed guest speaker, Honorable Justice R.V. Easwar. Over to you, Charmi.
Thank you, Niyati. It's my privilege to introduce Justice R.V. Easwar, sir. He is LLB, LLM, and a chartered accountant. He had joined the chambers of K. Shivraman, senior advocate, in 1975 in revenue laws, taxation, foreign exchange law, company cases, matrimonial cases, etc. He joined the Income Tax Appellate Tribunal, Ministry of Law and Justice in 91, and posted in Calcutta, Mumbai, Delhi, Bangalore, Ahmedabad, and again in Mumbai till elevation to Delhi High Court on 17th October 11. He was promoted as Vice President in January 5, as in Senior Vice President in November Appellate in November 9, and as a President of Income Tax Appellate Tribunal with effect from 4 June 2010. He is now retired. And with this brief introduction, I welcome you, sir, to the chamber. Welcome, sir.
Over to you, Aditya.
Good evening, everyone. Thank you, everyone, for organizing this. And thank you, sir, for agreeing to come join us today. I have had the benefit of having amazing conversations with you over lunches at time, as you're well aware. And when Niyati told me that she wanted, to invite you, I'm like, I'm the right man for the job, simply because I know what interested me the most, and what gave me the most advantage for the brief time I spent with you in Delhi. And I think it is time a lot of those things came to light today, so that professionals, young professionals, law students could also benefit from the large body of work that you've gone through. As Charmi was kind enough to introduce, we have been privileged to be a part of your journey. In fact, as I had told you when I came and met you for the first time, when I walked up the stairs of the ITAT for the first time as an intern, your name was there right on top. That was before you were in Delhi. This was around 2009, 2010, and I was only an intern. Little did I know that I would have the absolute pleasure and privilege of being with you after that and learning from you, and being able to interact so closely with you. You've had a career that has seen both the roles. You have adjudicated for many a decade, and now also you're very much in active practice. And I think I may not be very wrong to say that though there are other laws, income tax runs through your veins, because I have seen everything that is, how you prepare and how you argue the matters and how your thought process is. So we had a very firm belief that young professionals today and law students, a lot of them come even today and ask us, how does one get into a practice that is as niche as tax? What are the requirements for a good tax lawyer? And I have asked this question to you before, and I will be asking this to you during the conversation about how a young law student or a young professional who wants to get into tax should start his study of tax. Because I have a lot of people who do not have a CA background come up to me and say that tax is extremely fascinating, but they do not know how to start. And a lot of lawyers, and I'm sure you have also come across them, who say, I will do everything except tax because it is so hyper technical. So I think today, would be a watershed moment where someone who's an authority in tax, who has not only argued tax matters, but judged them across every appellate forum there is, after the first appeal level, of course, subsequent to that, who will be able to guide them. Thank you so much for joining us today. Welcome, sir. I'd like to start right at the start. How did you decide to do law as a career? Can you tell us, take us back to those days before Delhi High Court, before your senior designation, before even ITAT, and give us, an insight into your mind. where perhaps most of the audience or the people watching this would be today, right at the start, just how you started on your legal journey and how law came to be for you.
Yes, thank you so much, Aditya, for your nice words about me. And I'm very happy to be here and share my experiences. In fact, you have selected a very good format of an interaction, of asking questions and asking for my views on them. This is a very good way of, instead of it being one-sided, it ensures participation. It also tries to bring out insights which normally the speaker would not be even aware of, or not be, there wouldn't have been an occasion to share those experiences. So this is a very nice format you have chosen. Having said that, and to answer this specific question of what made you, it was about 1971. I must take you back to 1971 when I finished my degree, my BCom, from my hometown. And then it was my father's desire that he was a chartered accountant, and it was his desire that I should take up law as well as complete the chartered accountant's course. He thought it was those days. He advised me that it was a good combination. And today, those days, not many people were chartered accountants and lawyers. They had either one of those qualifications. And the place where I came from, there was no facility. Though my father was a chartered accountant, I could have done this articleship under him. But because he wanted me to do law simultaneously also, so we zeroed in on Bangalore, where one of my father's article student, as you know, was had completed and was practicing. In fact, it was my father's first uh, uh, student, and he had reasonably good practice in Bangalore. So he was willing to take me as his article clerk. I joined him, and then it was again because Bangalore had the facility of evening law colleges and morning law colleges, which was not available in Madras. That is Chennai today, Madras those days. It was not available. There was only one law college in Madras, the government law college. Bangalore had quite a few, and the advantage was there were many colleges offering morning and evening colleges. So I did my articleship during the day and then did my law. It was at that time, to be very frank, I didn't have any idea as to what I'm ultimately going to do. Whether I would choose the chartered accountant's practice or I would be a lawyer. That was not in my mind. It was perhaps a little too impressionable an age to take an independent decision, not like the present days. Present days, we see children in 15 very clear and decisive about what they want to do. But perhaps in the generation in which I grew up, it wasn't all that, clear. So I just thought my father has told me to do this, I will do this, and let me take it up from there. So, chartered accountants those days, I think the articleship tenure was about 4 years. And if you cleared your intermediate examination the first attempt, or scored 60% or more, not the first attempt, if you scored 60% or more, then you had a year's remission. So somehow or other, I could get that 60% thing in the intermediate exam. So my period of 4 years became 3 years, and the law college was also 3 years. It coincided. And to share this thing with you, the evening law colleges were just like, a time where you do some adda baji and come back. When there was absolutely no attendance requirement, And no, it was nothing very serious actually happened. Though we had a very good faculty there, there were guest lectures from leading lawyers of Bangalore. For example, we had Mr. G.R. Ethirajulu Naidu, who was Advocate General. He used to come once in a month or so to deliver some guest lectures on civil law and criminal law and all that. Then we had leading company lawyers and other civil lawyers coming there. In fact, the college, BMS Law College, which I attended, the when I joined, the correspondent was Justice Venkatachalaya. He was the correspondent, and before him, the correspondent was Justice Venkatramaya, who retired as Chief Justice of India and whose daughter now is Honorable Justice Nagaratna, who adorns the Supreme Court. So the college had a good, faculty, good reputation, good results. So we would go there, handful of students. Lectures used to be very informal. Sit down there, we'll share a cup of tea, and then they will tell us for 45, 50 minutes whatever they knew. It was like that. So it was actually, if I think back now, what I feel is it was that kind of lectures, a closed circuit lectures, the close rapport with those leading lawyers. We had a leading criminal lawyer by name Mr. Motaya, who routinely used to do a lot of murder cases, 302 cases. And as the cases were going on, he would share the experience here with us. So it is that kind of a thing which actually, kindled the interest in me that probably this is a more interesting field than adding figures and subtracting figures and doing balance sheets and all that. So that probably was the moment, sometime in 72, 73. And then Hindu law fascinated me, though of course it's not very relevant. With all that, I think it was that moment which really told me that I should try my hand in law. So when we had a specialized subject of taxation also in that, after that, it was so convenient for me that my father, as chartered accountant, he had a lot of cases before the tax tribunal, which was in Chennai. So he used to brief my senior quite a bit. So the natural choice was that he said, "You go and join his chamber." So I didn't regret being, and the other thing was that I took my own time to clear my CA examinations. After the 60% thing, which was, I think, a kind of a stroke of luck, I should say, I took my own time in passing my final examinations. In the meantime, I had cleared law. So the natural choice was to join my senior and then try to learn. Senior had a lot of tax work. He had some other work also, like some other corporate revenue laws, and so we had. He had a few similar civil matters also. So we did that, but after some time, you know, the law practice has a peculiar thing that when you start succeeding in a few, let us say, company law matters, or when you start succeeding in few criminal matters, I mean, water finds its own level, then criminal cases only start coming to you. It's not that you don't know arbitration law or civil law or other law, but then this is how it is. And then after some time, everybody knows you don't have time to take up any other matter. And then you start special. That's how specialization happens everywhere. So it happened to me the same way. After a few, I had some independent work also. Then I slowly, after 4 5 years, I got enrolled in 75. After 4 5 years, I was deeply into tax work. So that is how it gathered momentum. And
I also believe that the chamber in which you were during your formative years has thrown up some formidable names that have contributed a lot to the profession. So your senior must be quite someone. So can you tell us something about your days as a junior at the bar with respect to your senior? Because I believe a lot of leading lawyers have come from that extended chamber.
Yes, that's actually you can't imagine the kind of work he had. We had the Madras lawyers those days used to have something like a Ho and Co diary. There was a British firm called Ho and Co, HOE, which came up with the lawyers' diaries in larger than A4 size paper. It was the legal paper size, like this, half of it. The diary had 2 pages. No, he had the whole page full of cases every day. And there, even at any particular point of time, he had not less than 15 juniors. And many of the juniors used to come in the morning. Somebody would only brief him on some matter. Somebody will only draft grounds of appeal or affidavits, writ affidavits and all. Somebody would go like me. We would all prepare notes and go along with him. So it was many times the junior who came in the morning didn't know the other junior who used to come in the evening. So it was like 16, 15 juniors at that time, and my immediate seniors were formidable lawyers, and they had very sound background about civil law. One of them was adept in criminal law and constitutional law. So, and one of them was very sound in tax law, the fundamentals. So he became a member of the Income Tax Tribunal and retired as the vice president. So the chamber threw up quite a few, and then we used to see. I mean, there were no specific timings and all. It is sun up to sundown. It's like that. Sometimes my senior had the habit of getting up at 4:15 in the morning and reading. So there was nothing like a formal teaching that you should come at this time, you should do this and do that and all that. So if you were interested in knowing the subject and how he works, it's up to you to go to his chamber at 5 o'clock in the morning and then sit with him. He wouldn't mind who comes, who goes, he wouldn't even know. But he would definitely encourage you and ask you to look up the authorities and this and that without even registering your presence in that way. It may not even be. So I took about 2 years before I entered his inner chamber. Till the first 2 years, I used to sit in the other 3, 4 rooms, interacting with the other seniors there. So I didn't have the courage to go inside there. The Mylapore lawyer, as they said, the Mylapore lawyer those days were very particular that we didn't enter the seniors chamber with our slippers on. We used to leave it outside as if it's a temple, and we walked barefooted inside. So these were the traditions here in Chennai at any rate. And then after 1.5, 2 years, he started noticing me. Sometimes I would draft something, I'll place it, and he would make comments on the margin. So once he made a comment saying that the grounds are excellent, something like that. I remember. So I got encouraged. That is, and there was no formal teaching. Then we started going with him. He will ask you to summarize. He will tell me in 5 sentences or 10 sentences about this matter. So you test us like that. And then the conversations, mostly they were revolving around the judicial system, the judges. Then he would bring out anecdotes and bring out what some judge said in the judgment. He had a sharp memory. He would verbatim reproduce different subjects, not merely even English judges. So that way he was very particular that we read the autobiographies of leading lawyers, and his first recommendation was Chaglas Roses in December. He said, you must read it, if not for what he writes, you must read it for his English. He was so fascinated by Justice Chagla always. And he rated Chagla and Tendulkar as the best tax bench ever. So that was the kind. So we all took interest. In fact, we used to borrow books, go to the library, read those autobiographies and all that. Uh, this is the way. It was a very informal way of getting into it, and he never took. Uh, if he asked us for an authority, if we said that there is no authority on this point, he would deride us. He would ridicule us and say, if you say something like that, there is no authority, then probably you should be Halsbury. Are you Halsbury? He used to ask, are you Halsbury? That you say that there is no authority on this subject? No. So he would never take that for an answer. So this is how it was, a very old-fashioned, it was a grind to get noticed. And then once he noticed, and then he picked up, he used you for your talent. Somebody was good in drafting, somebody was good in, researching, somebody was good in arguing. He would mold you accordingly. And then this is what I had. That was the experience. And of course, the immediate years were so helpful. There was nothing like a jealousy or a rivalry or anything, that he is being marked cases, I am not, nothing like that. I mean, it was so, today if I think back, I think I'm so lucky.
I know this would make this entire conversation look scripted, but this is what I have on my table right now. Roses in December. Not that I'm reading it, but it just happens to be here. And I have had the pleasure of going through your library while in Delhi and borrowing the books. So even without knowing this, I'm glad that I have managed to carry on that tradition while I had the opportunity to read law in your chambers. And I remember picking up Mr. Sitalwad's autobiography from your shelf and spending months on it. Because it was very, very dry, but extremely full packed of information. So it's just something else. I now, at least now I know somewhere there was some inception of reading autobiographies from your tutelage, sir. So I'm sure a lot of us are also curious. I mean, because this program is mainly towards students and young professionals, and we live in a very different time. And things must have been very different back then. We know today that a lot of students do aspire to go into judiciary. I think it is it is very popular, especially outside Mumbai. But what inspired you to go in for the ITAT at that time as a member? And you must have gone in very, very young, because you had an extremely long career. In fact, you were president for a while. So you joined at one point of time as a junior most member. And when time came to leave that institution, you were at its apex. So, sir, can you tell us how come, why did you decide? What was the thought process behind joining the ITAT? And can you tell us some experiences from there that stand out?
See, you can't, I am not able to pinpoint what exactly. There are certain moments in your life, I believe, when decisions happen, and you look back after some time, you really are not able to pinpoint why exactly you did that. It was one such moment when there was an application and I was qualified, I was eligible. And then when I asked permission of my senior whether I should apply, he said, I have already sent one from the chamber to the tribunal. So you can be the second. This is what he told me. So with his blessings, I applied. Perhaps there was also the because I was at that time deeply into taxation, uh, not other branches of law, and there were not many cases I was doing. So there was also this slight kind of, perhaps at that time, with the family to support, and I was a first generation lawyer in the city of Madras, not in the didn't have the cushion, either financial or emotional, all that. So that was perhaps also playing at the back of my mind, to be very honest. So I thought this could be a turning point. And then some of my colleagues also did say that you are applying all right, but when it is offered, then that is the time when you really have to make up your mind. So when it came and I was selected, at that time I took the advice of my father whether I should really take it. He said that I should take it and try to make a mark there. And he also said that on one condition. The condition was that wherever I went, I should take my family with me. That was a very sound advice. He had his own reasons for saying so, perhaps. But later on, I realized the weight behind his advice only after I saw what some of my colleagues going a little wayward and all that because they didn't have the families with them. The stress wasn't couldn't be managed, and there were deviations. All that was primarily due to the fact that the family was not there to act as a kind of a shield. So this is perhaps the reason why he said that. He never disclosed the reason, but I had made it a point whenever I went, wherever I went, the family always came with me. And there were trials of the transfer, and the Supreme Court says transfer is only an incident of service; it's not a punishment. So we all suffered the incident of service, and we were not worse off for that. In fact, we are much better off when we had this Bharat Darshan. I was asked by Justice Venkatachalaya during the interview, I remember, that you are so young, you are only 39. If we select you and you will be sent on Bharat Darshan, you have your parents and all that at home. Would you like to go around the country? Uh, then at that time I mumbled yes or something like that. But actually, I really feel that the movement all over the country has given the whole family, each one of us, myself, my wife, my two children, the best of education, the best of exposure. One has to be careful about what we are exposed to. So the best of exposure with parental guidance and all that. So that way, this has been a very good experience, if not for anything else, at least for the pan-India outlook. I'm not boasting. I mean, there are so many who have a very broad outlook, pan-India outlook, even though they are located in the same place. Not that. But we were lucky to have this, and till today we have developed that kind of an attitude, different cultures. So we are able to adapt to the multifacets of life everywhere. That has taught us very good lessons. We have met beautiful people. We have met people who are full of kindness, courtesy, and love for us. I have not faced any problem at any place from any human being. My colleagues, my neighbors, anybody, they've all been so good to me. That kind of a life, I thought, was, in my opinion, it was entirely due to my post of being a member of the tribunal, and that has helped me in my personal life also quite a bit.
So at that point of time, you were a young lawyer based out of then Madras, and your first posting was at Calcutta, now Kolkata. And your headquarters as the president of the ITT was in Mumbai, because it was already Mumbai by then, though I'm sure you might have visited around Bombay time. And then you became a judge of the Delhi High Court. So you have covered pretty much the 4 metros, and I'm sure a lot of other cities in between. And every city, I'm sure, has a story to tell. Today, however, the incident has changed. The ITT doesn't have a full term anymore till superannuation from a very young age for members anymore. The rules have changed. There is a more limit to the period you can serve, and the age limits for recruitment, etc., have gone up. So, what are your views? I mean, is this a good thing, bad thing, the pros and cons? So, because you have also acted in administrative capacity as the president of the ITAT. So what is your view? Is this change good, bad?
one way of looking at it is as president. Uh, Earlier days, when this rule was not there, half of the time of the president was spent on dealing with the transfers. Request for transfers, don't transfer me or transfer me to X place, Y place. I want 2 years here, or 3 years here. My parents are old, this, that. So my president, Mr. Vimal Gandhi, used to jokingly tell us that somebody says that his father is 85, and then he asked him that if you are 58, your father is bound to be 85. So that cannot be a reason. So these were the things which the president spent half the time managing the transfers. And then there was the collegium system, which was mandated by the judgment of the Supreme Court in Ajay Gandhi's case. So I was the one who meticulously followed the collegium system. And I didn't yield to midterm transfers, or unless it was for very valid reasons. Somebody died, somebody family has to be taken care, all that. But otherwise, I was quite strict, and that invited a lot of criticism and sometimes bad blood between me and some of the persons who had made that request. But that apart, that's part of the game. This tenure, in my opinion, is bad. I am not making any bones of it. 4 years, and I understand that the government was not even willing to give 5 years. And the government opposed in the Supreme Court even one year's this 1 year more as a tenure. So 4 years, that relieves the president of dealing with all transfer requests, I believe, because if you are there in a particular place, you join, you retire there. Normally 3-4 years is the tenure in one place. So by the time the tenure comes to an end, tenure in the tribunal itself comes to an end. So that is one relief for the president. But that is not a big thing. The problem is the message which goes out. The message which goes out is that people perceive. It may not actually happen, but it is all about perception, which is to be guarded against. People perceive, the stakeholders perceive that 4 years tenure, why? And if you decide this way or that way, then it will be extended or not extended. So that kind of a Damocles sword should not be hanging on the members. It's a quasi-judicial body. And you are discharging of all the tribunals, you are discharging high stakes matters. Today, every case involves some hundreds of crores of rupees, international tax, transfer pricing, this, that, everything is huge stakes. Now, you think of this, the independence of the members to take the view which the judicial norms and judicial discipline and the framework of the law permits them. That independence is perhaps taken away, at least in perception. And then, as they say, justice should not only be done, but seen to be done. So you must have the feeling that I'm really independent. And you are that is gone. So I am not for this 4 year tenure knowledge. It's not good for the institution. Make an age limit. The same criticism was there when CAT members were given 10 years, and then they came up for further extension. 10 years or 5 years, I don't remember exactly now. So that criticism was always there.
Fairly awkward comparing ITT members to Caesar's wives, but because they say Caesar's wife should be above suspicion. But I believe that is what could be culled out from what you were saying, that the perception, even if there is nothing in wrong, the perception could be wrong.
Perception, yes, it is the perception which is really bad.
Right. So also, I know I'm going to ask a question that will make you smile right now, because I know it for a fact that you love the Delhi High Court. Because every time I mentioned it, your face used to light up. You loved the Delhi High Court. You loved your brother judges and sister judges out there, and you had some great times there. But how did it feel from going from from adjudicating only tax disputes to going to the High Court, where the assignments could and possibly did change. I mean, I know it for a matter of fact. I was told by some people in Delhi that at a brief spell of time you were also on criminal bails, I believe. I may be wrong. Please correct me if I'm wrong.
I
But
was.
of course, your strong background is always there. But from tax matters, and income tax matters, to having a whole set of matters in front of you. How was your experience at the Delhi High Court? Can you tell us something about it? Because I know your experience was fantastic.
Yes, actually, you are right. Delhi High Court, no offense meant to any other High Court, but because I have first-hand experience, it's one of the finest courts to work. Uh, there are there's good assistance from the bar, and then their infrastructural facilities are top class in Delhi High Court. And then at the time when I joined, I was welcomed as if I was one of them. Because culturally, Bombay and Delhi are completely different. So they were looking at me from as a Bombay man. So, the rivalry between Delhi Bombay is always there. But in my case, nobody uh, uh, kept that in mind, and all that was pushed. And the fact that I was from the tax tribunal was not held against me. They welcomed me like anything. And I will tell you, to answer your question as to how comfortable I was, there is a big difference between, again, this I am saying without any disrespect or offense to anybody, difference between persons who do tax matters, who practice or who have been tax judges and all that. Somehow I felt that they could easily slip into any kind of roster, be it criminal, be it civil, be it writ jurisdiction, whatever. Perhaps the same comfort cannot be said to be there, vice versa, because several judges were not, I mean, let us face it, were not very comfortable with tax. Though they were great civil judges, criminal law, and all that. The advantage which a tax lawyer always has is that he has dealt with a number of laws when implementing the tax law. So, personal law, criminal procedure, civil procedure, Hindu law, company law, arbitration, this cyber laws, evidence. So many laws have interplay with the tax law. So they have a fair amount of working knowledge about those laws. So when you are put into another roster, you very easily slip in to that. And if with a little assistance from the bar, you can be as good as anybody else in that. So I felt no this thing. In fact, after my initial stint in the tax bench, I developed a distaste for tax matters, and I wanted to be in other rosters. So I was a company judge for a long time in the Delhi High Court, and then I enjoyed that. It was very good, and there was very good top class assistance and all that. So somehow or other, I felt a tax lawyer is not so much at sea when he slips into other rosters, and it can be easily done. And I thought I wrote better judgments in company law than the tax law in Delhi High Court.
Sir,
Even criminal jurisdiction, I was there for where punishment was maximum 10 years. That roster was there with me. Then some of the CBA cases were with me. It was not difficult at all.
so now
But
I need to ask you.
there are some one of the very senior, very learned judges of Telangana High Court once told me that his colleagues, even it was in lighter vein, that when his colleagues were put in the tax bench, they even threatened to resign. So it was that kind of that was of course in lighter vein, but they protested. And the perception is, give me a minute more. The perception also somehow, though erroneous, is that it is a dry subject. This perception is there not only amongst the some of the judges, but also amongst the lawyers that tax law is a technical and dry subject, and it has to do only with additions and subtractions and some kind of mathematics and all that. But we all know it is not so. So it's diving deep into it. That perception should go. So this is the problem. That's why you have very less entrance to the tax specialization in the field of law. But that should go, in my opinion, because it doesn't mean that once you become a tax lawyer, you can't do any other law. There are so many laws. After all, it is only special legislation. The basic legislation is the civil law, which is the general law. And look at the first 100 volumes of income tax reports. None of the judges ever was a tax specialist, barring one or two. Others were not tax specialists, but look at the law they have laid down. So that's all. That all came from the basic reserve, the general reserve of the basic principles of the general law. So it is very easy to bring out the principles that are applicable to special legislation. They did wonderfully well. Subbarao, T.L. Venkatramaiah and all those, Patanjali Sastri and all, they were not specialist tax lawyers or tax judges. Those days there was no such thing. But look at the judgments. Look at the J.C. Shah's judgment. Look at reassessment and Vivian Bose, Hidayatullah and all. They wrote so well. Those principles are still valid. What we are now doing is only embellishing, putting a gloss here and there, and try to glamorize that. That's all. Otherwise, basic principles are laid down by them, and they were all civil law, criminal law giants. So that is it.
I want to now set the cat amongst the pigeons and ask you a fairly controversial question. You have been in Bombay, you have been in Chennai, now Chennai, earlier Madras, Kolkata, Delhi. What, according to you, which were the best lawyers that have appeared in front of you? Obviously, a limit there. And what made them so special? Most of our audiences may not know. But considering that you joined the bar in 1991, some legends, like I believe even Mr. Palkhiwala, you're the only person I know currently who has seen Mr. Palkhiwala argue. I believe he's appeared also when you were on the bench in the ITAT. No?
No.
But
in Calcutta, where there was a matter in which one or two adjournments were taken on the ground that he is coming to argue the matter, but ultimately he didn't come. And then by the time I came to Bombay, he was probably he became a little indisposed, and then so I had no opportunity to hear him. But I have seen him do matters in the Madras Income Tax Appellate Tribunal. One of the first matter in which I saw Mr. Palkhiwala was that first leasing company, where they said that this leasing itself amounts to business, and therefore you will get investment allowance under 32A those days. So that was the case in which I saw him argue the matter. Apart from that, there was one occasion in 1978 or 79, if I remember right. There was a judgment of the Madras High Court which we had lost, and then which we had filed an appeal to the Supreme Court, and it came up. And then it was a fairly big client, and so an American-based company. So they wanted him to be engaged. So my senior had some difficulty to go to Bombay to brief him, and suddenly he looked at me and said, "Will you go?" Oh, I mean, I was so nervous, so happy, and I very gladly said, "I will go." But very unfortunately for me, Mr. Palkhiwala said that he doesn't need any briefing in this case because he knew it thoroughly. So he said, it was, if I remember right, it was a carborundum company or something, which is Justice
most
Khanna's.
memorable lawyers and what made them so special? The
So
qualities.
in Calcutta, Mr. Bajoria was very, very good. I heard he is not nowadays coming to court, but he was one of the finest lawyers I've ever seen. Dr. Paul, of course, was a very good orator, and uh, he was quite forceful, uh, and then Mr. Kalyan Roy, you may not have heard, was a very incisive brain, but he had a bit of nasty temper. So that wasn't very much liked by some of the members, though I had no problem with him. These three names, were some of the chartered accountants whose names now I forget. They also were very good. Bombay, of course, was Mr. Dastur is there. Uh, then the way in which he does the cases, I've told him also. I've told him that it resembled a top class neurosurgeon at work. Clinical precision. See, one wrong move and it could, that kind of that's why the neurosurgeon is rated to be uh, almost like God. So he resembled to me, at least, that kind of very precise, very incisive, very forceful without raising the voice, and all the facets of the case would be covered by him. Others were also there in Bombay. His associates, there are so many now, who are so good. So I don't want to take names because I may omit some names, and therefore, and
Yes.
Delhi also had a good, very good bar. Of course, some senior lawyers were there. Mr. Vora is there. Then Mr. Agarwal, several. Of course, I would rate my senior as one of the top 5 lawyers whom I have seen and worked with. That these are the names which immediately, and there are
Yes.
in Delhi High Court, lawyers who do the matter so thoroughly. At this distance of time, many of the names I can
Yes.
recognize the faces, but I can't recollect the names. But
There always has to be controversy. That is why I put this question to you. So I need to apologize because I'm sure that some names
no.
might have
So I will
escaped.
tell you. I will tell you one thing. I don't see the need to evade this question because the judge looks for assistance. He may know the subject. He may know how to do it and all that. But ultimately, when proceedings are there, he looks for assistance, and that assistance must be forthcoming. Now, if the lawyer is not able to assist, then it's not that the case should be lost, but the judge has to do his own research. There's nothing wrong in it. But therefore, a judge has to look upon the lawyers as something as a source of knowledge to help him come to a conclusion, fair conclusion. So there is no point in deriding any lawyer who appears before, particularly if he's a junior lawyer. In fact, I always held the belief that if a junior lawyer appears and he must be given 15 minutes more uh, for various reasons. He may not have, he may not be able to put the case in the manner in which he wanted. He may be struggling for words and right expressions and all that. That should not be held against him. And as a practicing lawyer, you all know that if you want to argue something in the court for half an hour, you should have prepared it for 3 hours at night. You must have burnt midnight oil. And then when he comes and gets up, and even before he utters a word, if you say there is nothing in this case, sit down. I mean, that will snuff out the whole career. In fact, there could be some case where you snuff out the whole career. If you have made up your mind to decide against him, give him 15 minutes more. Because the last word he utters may turn the tables in his favor. That is one thing and then I also believe that when you write the order, if it's a young upcoming junior, 2 3 years into bar, if possible, write one or two positive words and praising his work. This I used to routinely do. Whether I accept this case or did not accept this case, I always try to do that. That will go a long way in his resolve to become a leading professional. When snuffing out is very easy, but that shouldn't be done at all. You try to encourage, and after all, he's trying to help you come to a conclusion. I mean, you have invited him. Actually, I look at it that way. The court has invited him to assist the court to come to a conclusion, and he's doing that. He may not be as successful. Maybe in 5 years down the line, he'll be highly successful, but that is no reason to deride him. That's the principle which I followed always.
So I'm sure a lot of the juniors at the bar then who are now seniors in their own right would really appreciate that. But speaking of juniors and seniors, a lot of people, nowadays, you'd be surprised, though you said that tax is very super specialized. There's a lot of interest in tax litigation, and a lot of people do want to join tax litigation. So, presuming for a minute, if I role play a fresh law graduate or a law intern who has had the good fortune of running into you at an informal event where I do have the privilege of talking to you for 5 minutes, and I ask you, sir, how do I set up a tax practice? What should I do? How should I start studying? I do not have a CA background. I mean, my audience may probably know that I do not have a CA background, though I did it, I never finished it. What do I do to understand tax? What do I do to, invest myself in tax? How do I go about it? Because, the subject of income tax or even indirect tax now is fairly complex. The Income Tax Act is a code in itself, and GST, half of it really comes through notifications nowadays, and GST tribunal, the GST council recommendations and decisions. So how does one set up a successful tax practice as a junior, and what are the do's and don'ts?
First of all, let me clear this thing that the preparation and the kind of dedication which is required for a successful tax practice is no different from what one would undertake when they take up civil law practice or a criminal law practice. No different. Hard work and dedication to the subject is what is required. Then there is a lot of passion that needs to go into that. It is wrongly thought of as a little blue-collared or sophisticated line field, and there is a lot of scope for original thinking still. Because many of as we all go through the law reports, we can see that the interpretative aspect of the Income Tax Act is quite large. And one needs to be always up to date with the case law, and that is a little becoming very difficult nowadays with the deluge of law reports and with online journals and all that. You never know. Somebody throws a judgment of the Allahabad High Court which you have never seen, and he has seen it the day before the hearing. So that creates a lot of difficulty in coping. So that difficulty perhaps is more in this field, in this branch of law. And then the frequent amendments. One needs to be up to date with the not only with the case law, but also with the amendments. And as you said, GST regime is mostly circular regime, and one needs to have probably files and files of circulars to follow the chronology and then try to make sense out of it and present it to the court. So these are it's a fascinating field, this tax branch, but it requires as much dedication and hard work as a lawyer would undertake to shine in any other branch. No different. And one shouldn't take it lightly. If you have a good senior, it's well and good. But if we don't have, it doesn't. It is not a minus point. You can always learn, sit in the court. In fact, personally, I felt that the initial days, one should sit in the court if he or she has time, sit in the high court, in the tax bench, and listen to those words being said and how matters are being presented and all that. That will give you a good fillip uh, and some original ideas. I think these are the basic requirements.
And what you said right at the start, first 100 ITRs.
First 100 ideas is the law laid down. That was my senior's favorite line. He said the first 100 ideas is, in fact, he used to suggest that take one ITR volume and try to read all the cases there over a week. Those days, volumes were thin, 200 pages or so, and there was only one volume or two volumes a year. Today, I don't know, maybe 15, 16 volumes a year, but those days it was very. So read those cases and then try to digest, make a digest and all. And one thing is very important, I forgot to. Preparation of notes while the case is being studied. That is very, very important. I always did it, even now I do it. And as member, as judge also, everybody does it. Notes help you marshal your thoughts when you ultimately present it before the court, or if you are a judge, when you ultimately draft your order, your judgment. So taking down notes is very, very essential, because minute facts, the brain can take only as many facts as it can. If you have 5 cases in the court on a particular day, you tend to get a little, confused also, especially in the initial days. So the role of preparing notes should not be undermined, and one should not be, one shouldn't feel a little shameful about it, because there are many who think taking notes is a little, it's like a schoolboy thing, and that is for your information. The Bombay is one of India's leading lawyers, Mr. Bulabai Desai. Somebody told me that he's the best lawyer he has ever heard, long before our times. Mr. Bulabai Desai used to prepare meticulous notes. So there's nothing wrong and nothing, demeaning about taking down notes and then keeping it handy while you argue the case before the tribunal or the court. So that is very important.
Yes, sir.
And keeping up to date with the law reports, that is also equally important. You never know. Some judgment is reported which is in your favor. You haven't looked up.
There's also
Remember,
a cheat sheet.
I
There
remember
is
in
also a cheat sheet. Sorry, sir, you were saying.
there's also a
Cheat sheet that I have, because once you're done, I have to share one experience with you. Yes, sir. Please listen.
There was a matter in which two leading lawyers were appearing, and then it was coming up or something. So the lawyer who was on his legs the earlier hearing, he wanted to say something. The other lawyer was trying to interrupt him and say, "Please don't." So that he was getting angry that he is being interrupted. But then the court wanted to know, why are you interrupting? So that lawyer very fairly produced an order, said this is reported yesterday in some particular tax journal, and this is in favor of my learned friend.
So that is quite something. But I was saying,
No, it was not only it. He was very fair, but the other lawyer was equally a leading lawyer. Looked very small that he hadn't looked up a judgment in his favor.
sir, that is, I think, something that used to be the hallmark of the lawyers at a point of time. I do not know whether how much that is followed today, but that used to be there. But I was going to give the audience today a cheat sheet into working with you, because I've had the privilege and the pleasure. My fondest memory from Delhi, in fact, is sitting in your cabin, not in a conference room, uh, preparing for a matter. And there was a very peculiar way I used to go about it. You used to open the act. I used to open the act. I used to sit right across you, and you used to say, Aditya, read. And I used to read every line, and you used to make me pause at the commas and the full stop, and then figure out the interpretation and force me and also interpret it yourself, and have a discussion, perhaps line by line, on the most critical parts of the statute. And at some critical juncture, if there was any sort of discrepancy or some question, used to be like, Aditya, go to Sampath Iyengar, get Sampath Iyengar from the library. And we used to open up that section where the entire history of that section, the notification, everything used to be there, and the preparation used to be so meticulous. And that was just so I mean, I'm usually never at a short of, at a loss of words, but by my current lack of erudition, I'm sure, sir, you can understand how much it impacted me, being able to have my interpretation guided at every second, from one end of a proposition to the other. And I think that level of preparation, just was something else. That was something that, and this is current, this is not very long back. This is you practicing in the courts after a successful stint at the bench. This is how you prepare even today. And I'm sure your current junior also has, stories like that to share. But so, which brings us to the next section, because we've covered the High Court. So you have also been a part of arbitrations. You presided over a lot of arbitrations. And a most interesting aspect is that you had headed the Direct Tax Reform Committee in 2015, that was set up in 2015. And then the recommendations, I believe, were given in 2016. An interim report came out, and then a final report came out. And our Honorable Finance Minister this year is also looking into revising the direct tax code. And, there's a lot of talk and chatter about simplifying tax. So what do you think is the way ahead for the Income Tax Act? I mean, a lot of water has flown under the bridge since 2016. I mean, the Income Tax Act, reassessment sections, etc., are almost unrecognizable, with a lot of new aspects coming in, and of course, frequent amendments. So, but what is the way ahead for the Income Tax Act, sir?
Now, let us get this very straight. I am not a subscriber to the view that an act should not be amended. I mean, that's an act like, of course, the Income Tax Act. Main reason is that it's a kind of on the ground, at the ground level, it's a kind of a competition between the business and the government. I mean, the business sometimes goes ahead, the government lags behind, and then it makes an amendment, and then the business finds different ways, and the government finds also different ways to plug that. I mean, this it's a continuous, constant race. So, I mean, no disrespect meant to that greatest lawyer, Mr. Palkiwala, but I was not able to agree when he said in the foreword of his book that today the Income Tax Act is a disgrace, national disgrace, he said. I mean, uh, I thought that was an unfair comment. I mean, in my humble opinion, when there are ways and means adopted by the business to say circumvent the law, or to keep away from the restrictive provisions of the law, the government has every right to to plug those loopholes and come back with further amendments. So in an act like the Income Tax Act, uh, you really can't avoid amendments. The fact that some amendments are badly drafted, necessitating frequent changes, or very very complicated provisos and explanations and all that, that's a different thing. But the right as such must be considered. So uh, simplification, what I am coming to is simplification of an Income Tax Act, with due respect to everyone, is perhaps a myth. I can share my experience being in this head of the simplification committee. Today, somebody may even question, then if that's a myth, why did you accept? As I said, when you have complicated business models, complex business models, oh, there are a lot of multi-structuring, layering, cross-border, this, that, so many entities being created and all that. You need to deal with that. So you must have, and these amendments are not going to be simple. Definitely, they're not going to be. So let us step back and look at the scenario. Is it really worth trying simplification of the act? Are we all not going towards a kind of a what you call a mirage? I would tend to think so. So let us uh, keep the act. I mean, 290 sections, 290 sections is a little unhandy. But then simplification can be perhaps thought of in the procedures. That is perhaps possible. And today there are one of the burning issues is that what happens when the person who deducts tax doesn't deposit. They say that why do you worry? It can't be recovered from you, from the deductee. Fine, that is one way of looking at it, but the deductor goes scot free. What are you going to do about that? All those things may come up. That's a very very simple example I have taken. Procedural things can be simplified. They have tried to simplify by this large scale computerization, which and I can't avoid the subject of faceless assessment, which was expected to simplify things, but it has complicated things because most of the litigation in the High Court by way of writ petitions in the last 2 3 years, since faceless thing came, is about the process adopted and absolute disregard for fair play and the rules of natural justice. So perhaps instead of concentrating on simplifying the act, let the act be there. You want to make an amendment, delete sections, omit section, introduce sections, introduce provisos, delete provisos, do all that. But then mindset change on the part of the persons who implement the act is required in the sense that uh, fundamentally everybody should have this justice and fair play in mind. And then targets, revenue targets. Again, these are all not something which are new. Everybody knows revenue targets, collection targets are all driving persons to adopt means which are not quite in conformity with the law. That should be focused upon instead of going after the amendment thing, because we all know, again, no disrespect meant to anybody. When we had the code of 2010, somebody said it has 298 definitions in section 2. It had 298 definitions in section 2. So is that simplification? Certainly not. Certainly not. So in the committee, in the committee which I headed, there were 10, 11 members, 10 members or 11 members. I mean, everybody would throw up a complex problem when we think of simplification, so much so that it was completely outside the scope of simplification. So you couldn't do anything about that because the kind of complexity of the business had to be given. That complexity of the business, you needed to have complex provisions to deal with all that. Otherwise there was leakage of revenue. So I think we should take a step back about simplification, not speak about it anymore. Focus on the mindset and the kind of procedures adopted by the taxmen, where justice and fair play are given the backseat. That should be avoided. That may work wonders.
So we are going to also address arbitration because a lot of people are interested in that now. what do you think? Are there any defining qualities over and above, or maybe different from those that make for a great lawyer in a list between the government and SSC, and a list between two private parties, like it happens in arbitration? What do you think is the hallmark of a lawyer who's good at trial work or arbitration? Because uh, you know, we have seen how matters are sometimes conducted at ITT level, especially, or sometimes even at high court level. But when it comes to arbitration, matters are a lot more keenly contested, and both the parties are a lot more aware. So, what are the hallmarks of, with respect? What advice would you give to those young lawyers who would want to make a career in arbitrations?
Yes.
As counsel.
In fact, I'm glad you asked this question. The Today the arbitration is an accepted thing, and it's a very good field. In the sense, the advantages are that you set your own calendar before the arbitrator. It's not like in the court somebody else sets the calendar for you and then adjournments this that. Nothing like that. The arbitrator is holding court for your case, and you can, law says within 1.5 years you need to complete, otherwise the mandate goes. That's a very good provision. It can be extended by the court, and they do extend. They are quite liberal, as I have seen as arbitrator. They are quite liberal in extending, especially when they are convinced that the arbitrator is progressing in the case, and for some reasons it's not completed. So they do. And then, apart from selecting my own calendar, there is a specific provision in the Arbitration Act which says that the Civil Procedure Code and the Evidence Act, per se, they do not apply. So you cut out all the cumbersome procedural things, that filing an application with this thing in court, listing, getting it listed, and application has to be responded to by the other side, and then rejoinder, this, that. Today, all that is removed. It's a very informal, just like the Income Tax Appellate Tribunal. And there are many arbitrators, very highly respected judges who are arbitrators, with whom I have sat, and I have learned that most of them, they have dispensed with rejoinders. So a big, the rejoinder is the parties always ask for 4 weeks, 6 weeks time to file rejoinders. So a lot of time is eaten away. There's no rejoinders. Then when it comes to taking evidence, oral evidence, they have said that cutting out the rigmarole of the Strict Evidence Act, they have said that no need to put suggestions to the witness. We will not draw any adverse inference because of the presence or the absence of suggestions. You can avoid suggestions so that you can cut down the cross-examination to a reasonable. That is one thing. And then for every application can be listed short. You can ask for a reply, and that's it. And then in many of the cases, especially the commercial disputes, you don't even need to have oral evidence. The parties are willing to argue the matter straight away after the pleadings are complete, where everything is in documentary evidence. These are excellent provisions. And then an arbitrator lawyer, his mind is completely free of the procedural aspect of the matter. He has to concentrate only on the substance of the matter. Choose his time. There is no interruption. There are no disturbances, nothing. It's between him and the arbitrator. The other side is there. And then now most of the arbitrations are done online. I do all of them online because there are matters from Delhi. I can't go to Delhi every time. And that is a great savings in expenditure. And also, arbitrations can be conducted at 7 p.m., at 8 p.m., or 7 a.m., 7:30 a.m. You choose your time, convenient time. They all appear online. They do several arbitrations on the same day. So it's an excellent field, particularly for young lawyers who want to make a mark, and it's all substance and no procedural wrangles. And that way, it is a fantastic field. And the results are out in any case within 1.5 years, maximum 2 years, because if you have an extension or whatever. And then hearings are also informal. You don't have to stand up and be formal, address this, that. And they're very quick, very business-like. 1.5 hours a day, 2 hours a day maximum, or one session a day maximum, done. 2 sessions, 3 sessions, it's all done. So I am a big votary of arbitration. And the young lawyers today, at least I know as a fact in Delhi, they all like to do arbitration. And they do very well. It must be the
Thank-
question must be the same in other places like Bombay and Kolkata and all those places. Chennai also has a very good arbitration. This thing, there are some arbitrators who specialize only, they don't go to any other court. They do only arbitration. And then today you have Section 34 and all that, which have cut out. The scope for interference with an award today is very, very, very limited. And courts are very reluctant to interfere with the arbitrator's award. And the principle is parties have selected this procedure, and then how can they complain? Unless there are extreme cases, that of course is an exception. So arbitration is young lawyers should go more for arbitration is what I feel. There's a lot of scope, and of course it is remunerative as this thing. In fact, even more. Leading lawyers appear. There are very big names. They appear in arbitration. So assistance is also good.
So I'm sure a lot of young lawyers will be very, very happy with that. So there's just this one question that was brought to our notice, which we wanted to ask you. In general, it has nothing to do with tax or arbitration, but there are rumors. Certain people now saying that there is interference with the functioning of the judiciary by political or vested interest, etc., etc., and that judicial activism is getting out of hand. So would you like to have any thoughts on that any short this thing? Because that is a more burning current topic, how a sign of times today, let us just put it that way.
The two aspects. One is what you call vested interests, whosoever it is. Number two, excessive judicial activism, uncalled for judicial activism. No, as long as there is a judicial system, and as long as there is a political system, and as long as there are stakeholders, some of them are real stakeholders, some of them have vested interest, they do. Now, it is all up to the judge, the strength of character. Those are the tests as to how much strength of character the particular individual has. It is perhaps the parties or stakeholders, whoever they are, private individuals or public bodies or political parties or governments, they may not think much about it, about such values. They may have their own interest. They may try to further their interest by any means. I mean, we need to understand the human nature that way. But if the judge is not pliant and he puts his foot down and said, I am independent. I owe my this thing only to the law books, to the statutes, nothing else. As some intern of Justice Learned Hand asked, to whom do you owe allegiance? Learned Hand was a famous US judge, though not of the Supreme Court, but his reputation was sometimes even better than the. So somebody asked him, an intern, and he stood up and pointed out his library and said, I owe my allegiance to those books. That's all. So if I owe my allegiance to those books and the law, what he meant was the law and the judicial precedents, I put my foot down. And it is always the first time you put your foot down, and then there will be nothing forever. That is a test of your strength of character. So everything depends on me as a judge, whether to yield or not to yield. There's no question of blaming anybody. You must understand human nature. If somebody puts pressure because of he or she has vested interest, then I shouldn't be allowing that to happen in my court. That's it, period. Then everything will back out. Judicial activism, of course, there's sometimes There are occasions when the judgments go a little overboard. It's a burning subject. The same orders, somebody says this is judicial activism not called for. Somebody says no. If other constitutional machinery fails and is not effective, somebody has to bell the cat. And what is wrong in the judiciary if it takes up a little active or proactive or assertive role? What is wrong? I think both are valid arguments, and it is today. One thing very generally I will state. Today there is the public discourse and debate painfully is very shrill, distorted, and goes on political lines, if I may say so with due respect, goes on political lines. There's no neutral, objective voices are very, very less. I won't say there are no such voices, but the voices are very less. Therefore, to a person, to a layman, he probably doesn't have good guidance as to which will help him decide whether this particular order is in represents judicial activism which is not called for or which is called for. If the whole drainage system in a town isn't working, of course it is the job of the corporation or the government, whichever. But then if they don't work and people are suffering, then should the court hold its hands and keep quiet is one question for which there can be two answers. Somebody may say no, they can't. Somebody may say yes, they must. Ultimately, it's the welfare of the people. If the welfare of the people is topmost in the minds of the court, what is wrong? But then there may be cases when there may be people may perceive it to be uncalled for interference, and those cases are also there. So it will depend basically on I mean, there can be no yes or no, answer to this thing.
So this conversation has been the most fulfilling meal, but there is scope for dessert. So I reserve the best question for the last, and it is the shortest and the sweetest. So what, according to you, is the one most definitive judgment that anyone or everyone who's interested in tax, I'm saying one across all time. I know there would be a lot of contenders for this post. The one judgment that every student of tax law should read, the one, your favorite judgment, let's just put it that way, that has influenced you the most, or your thought, or some sort of critical thing, something that may have changed your opinion, because you must have gone through so many judgments throughout the years, and it doesn't need to be a Supreme Court judgment. Any one judgment. Do you have a favorite, sir?
Only any one judgment of the Supreme Court.
Any judgment of any court, not necessarily the Supreme Court, which according to you is perhaps the most critical, or something that you enjoyed the most, or something that really developed your appreciation for tax law, made you think differently or question the things that were in your head in a positive way, or your favorite judgment.
That is a very, a very difficult question to
Yes.
answer. Because if you probably a few, I can't point to a single, but probably a few subject-wise. Perhaps you can say tax law, Hindu law combination. I was very much impressed with the judgment of the Supreme Court in what is that? Nowadays I forget the names where they said that husband wife can constitute a joint family, which was somewhat of a it raised eyebrows. Narendranath was one. So subject wise, I can tell you this, and then you had some judgments were wrote very picturesquely in the sense. One of my favorite lines of Justice H.R. Khanna was in that Krishna Prasad's case, where he said, where the question was whether a sole co-partner, unmarried, whether he can constitute a joint family because he inherited property. So he said, uh, he's a lonely wayfarer till perchance he finds a mate. This is what he wrote. So this has impressed me. And then Lakmani Mevaldas is one of the favorite judgments. Then uh, I'm very impressed by Justice Pankatramaya's judgment in Sri Meenakshi Mills, very old judgment, where I recommend every one of you go through the judgment line by line, comma, full stop, everything, because it gives you the complete picture of what is a question of fact, what is a question of law, what is a mixed question of fact and law, and at what point the High Court can interfere with the orders of the lower courts when Section 100 CPC and all that. These are some of the judgments, and there are hundreds. I have now confined it only to tax law. In recent times, also in recent times, I have been very much impressed by. I know there may be a lot of questions about this. Very impressed about the Supreme Court judgment in Ahmedabad Urban Development Authority's case for its complete dissertation of the GPU cases, general public utility cases, and the way in which it has been threadbare analyzed. That was one recent judgment which I can. Of course, there are some recent judgments which are totally disillusioned me. I don't have to tell you
Yes.
about those cases. Then some original thinking, that if you want those cases like Vatika Township, Justice Sikri's case, I mean, the way in which the questions have been approached, there are so many. I mean, I can't pick out a single judgment there. And I can say some of the judgments of the Delhi High Court in company law, when I used to was a company judge. I used to read Justice D.K. Kapoor, Justice H.L. Anand, and all those judges, how they wrote, the way in which they wrote the judgments, like a story. It is wonderful to read. Uh, and I was also always a fan of Justice Chagla's, terse
So this is in December onwards.
yeah, excellent. I mean, there are so many which I can. I mean, it is beyond the scope of this webinar
Yes, sir.
to.
So thank you so much. We have actually been so engrossed that you have been kind enough to condone me for going way beyond my allotted time and not following the chess clock system for this conversation, which is now so in vogue in arbitrations. Thank you so much, sir. This has been truly enlightening, and it brings back memories of me having one-on-one interactions with you. And I'm sure the audience also will find it extremely useful.
Actually, sorry to interrupt. One part of this my experience throughout, which I omitted to mention, was the kind of colleagues I had particularly in the tax bar. Uh, we are such a close knit unit. We used to help out each other, though we were from different chambers. I think I have discussed it with you sometimes earlier also, but for the benefit of others, we are still close. We are still in touch with each other. One of them became a judge of the Madras High Court. One of them is now a top senior counsel in the Supreme Court. And I became. We all excelled. I mean, at the cost of modesty, we all excelled, and a large part of it goes to the type of camaraderie and then the type of support we had for each other. That was fantastic. Everybody should be lucky to have that kind of a group. So that I had.
Thank you, sir. That was actually the sweetest moment to let this end. It led leading the case to its logical conclusion. Thank you so much. And just as I'm signing off and handing us over to Niyati, the thought just struck me with this limited tenure now that will be there for ITT members and the age at which they'll be recruited. We may not have a repeat of your story from here on forth. There were one or two, but we may not have a repeat of your story here on forth. There were few that came before you, and I believe one came after you, who were elevated from the ITAT to the High Court. That would make you, sir, one of the last out there, and we thank you for this. Thank you for sharing this wonderful journey.
Thank you very much. Thank you.
Over to you, Niyati.
Thank you so much, sir. And your journey and your perspective from the bench, like as a litigating lawyer, even I could relate a lot to it. And now even I have a pretty good idea of what is expected from an advocate. So thank you so much for sharing that. And I'm sure your advice will go a long way with our students and young professionals as well. So now I request our student member, Akash Shirore, for the formal vote of thanks.
Before
Yes,
that,
sir.
Yes, sir.
may I? Aditya mentioned, sir, that he apologized for extended session. But I would say we all apologize, but happily to have the extended session, to have an opportunity to listen to you, sir.
Absolutely.
Yes, please, Akash.
Yes, sir. So thank you so much, sir. As we come to the conclusion of yet another enriching session of Udaan, I would like to extend my heartfelt gratitude on behalf of the student committee of the Chamber of Tax Consultants. First and foremost, I would like to express our deep appreciation to Justice Sri R.V. Eswar, sir. Sir, your journey from bar to the bench and back again, and your valuable insights into the field of taxation law have inspired and educated us today. Your insights today on challenges and opportunities in building a successful career in law, particularly in taxation, has provided great value to all the students and professionals out there. It has been a privilege to learn from your experience and expertise, and also an overview on simplification of taxation law and arbitration. A special thanks to our host, Mr. Aditya sir, for guiding today's session smoothly and ensuring such a vibrant discussion. We are also grateful to all the participants, students, professionals alike who joined us virtually for this session. Your engagement and enthusiasm are what make these events truly worthwhile. With that, I conclude today's session. Thank you once again to all, and we look forward to seeing you at our future events. Thank you. Thank you so much, sir.
Thank you
Thank
so
you
much.
so much. Good
Thanks a
evening.
lot,
Thank
Ishwar,
you
sir.
very much.
Thanks a lot.
Thank you. Thank you very much. Thank you.
Thank you, Aditya.
Thank you, sir.
Thank you, everybody. Thank you.
Bye, everyone.